the deceased had changed his phone PIN and password. When she was unable to access the information, she locked the deceased at home, preventing him from going to work for some time on that day. Now, the second disappointment was the love letters the accused person discovered that the deceased was still keeping many years after he broke up with the former girlfriends. Now, the discovery led to upbraiding of the deceased by the accused person and finally to this attack. The accused alleged that the deceased had sex with her, knowing that he was HIV positive. I rejected that explanation. Not only was it raised at the defense stage, but also for being an afterthought. If we are to ask why the deceased in this case died, was it over frustration to access his phone? Was it for keeping old love letters of persons who had long moved on? Or because the deceased walked away from the accused to go to work without her? Now, the reasons for taking the action that led to the deceased death cannot be justified by any standards or instruments of measure. The court also considered how the murder was executed. The accused did not stab the deceased in quick succession. She stabbed the deceased one at a time. It was as if she was sampling with pleasure each and every stab she inflicted on him. And those who witnessed the accused's actions told the court that they were traumatized over the act for some time. I consider the fact that the accused ignored pleas to let go the deceased by desisting to stab him any further, that she did not stop. Even though the police say that they were inadvertently lost the pictures of the scene, the evidence of those who went there created a vivid picture of how it looked after the incident. They said that there was blood all over the house of the deceased. There is no doubt in my mind that the accused person was not remorseful for this offense. The manner in which she carried herself before this court is evident that the impact of what she did is yet to hit her with remorse. Now, counsel for the accused has urged that the accused has, while in custody over this case, been religious, disciplined, talented, and helpful in terms of leadership. She is said to have undergone many courses. These factors are relevant when considering sentence, among other weighty factors. The loss of chance to further studies is not persuasive, as the prison service does aid inmates to undergo courses and studies, very much like the ones for which she submitted certificates. Now, the defense counsel quoted the Supreme Court petition number 15 of 2016. It was not supplied, however, it is of notoriety, and I managed to get a copy of the judgment. The full citation is Francis Carrico Muruateto and another, and the Republic and others, 2017 Kenya Law Reports. Now, counsel urged that the Supreme Court declared unconstitutional the mandatory nature of the death sentence and urged that this court could pass any other sentence. The Supreme Court in the cited case sets out guidelines to assist the courts in the determination of the sentence where mitigation was not considered prior to the said case. Now, the guidelines are as follows, and I quote, "As a consequence of this decision, paragraph 6.4 to 6.7 of the guidelines, that is the sentencing guidelines, are no longer applicable. To avoid a lacuna, the following guidelines with regard to mitigating factors are applicable in a rehearing sentence for the conviction of a murder charge: the age of the offender, being a first offender, whether the offender pleaded guilty, the character and record of the offender, commission of the offense in response to gender-based violence, remorsefulness of the offender, the possibility of reform and social readaptation of the offender, any other factor that the court considers relevant." We wish to make it very clear that these guidelines in no way replace judicial discretion. They are advisory and not mandatory. They are geared towards promoting consistency and transparency in sentencing hearings